At this time, I would like to call the meeting to order at 7:02 p.m. Today is Thursday, June 13th, 2024, and this is a meeting of the Rent Stabilization Commission for the City of West Hollywood. We would like to begin by acknowledging that the land on which we gather, currently known as the City of West Hollywood, is the occupied, unceded, seized territory of the Gabrielino Tonga and Gabrielino Kizh peoples. Commissioner Bass, would you like to lead us in the Pledge of Allegiance?
Please stand and join me in the pledge.
Mr. Secretary, may we have roll call, please?
Commissioner Bass,
Here.
Commissioner Kirpies,
Here.
Commissioner Rory,
Here.
Commissioner Topshin,
Here.
Vice Chair Moore,
Here.
and Chair Wright is absent but notified us they will be joining the meeting.
Thank you. We have a quorum. Has everyone had a chance to review tonight's agenda?
I have one change.
Okay.
On item 10A, the direction of the commission was to reverse and remand the hearing examiner's decision. It currently reads to affirm, so I just want to change the language in the agenda on that.
Okay.
I
Do we
move with that amendment.
Do we have a second?
Second.
Commissioner
Okay.
Bass?
Motion passes.
Sorry. Commissioner Bass,
Aye.
Commissioner Kirpies,
Aye.
Commissioner Rory. Aye. Commissioner Topshin,
Aye.
Vice Chair Moore.
Aye. Motion passes. We have the minutes for the meeting of May 23rd, 2024. Has everyone had the chance to review them?
Motion to approve?
Second.
Okay. Mr. Secretary, may we have a roll call vote, please?
Commissioner Bass,
Aye.
Commissioner Kirpies,
I'll abstain.
Commissioner Rory. Aye. Commissioner Topshin,
Aye.
Vice Chair Moore.
I'll abstain. Motion passes. Do we have any speakers from the public tonight?
Yeah, no speakers.
Next item is the manager report. Ms. Aviles, may we have the report, please?
Good evening, commissioners. My name is Gloria Aviles. I'm the Rent Stabilization Supervisor, and I'm happy to announce that we finally have our new Rent Stabilization Manager. I'm introducing him, Cameron Kessinger, and he will take over the meeting from this point on.
Hi, everyone. It's nice to meet you. I'll speak a little bit about myself, but before I start, I wanted to recognize Gloria, who for the past 6 months has been the acting rent stabilization manager. I think she's done an incredible job. I've seen several videos in the past, but also in City Hall with all of the responsibilities that she's assumed. So I just want to take a moment to recognize Gloria and all the incredible work she's done since Jonathan left. Before I get to look at a calendar, I'm very excited to work with all of you and to assume this position. I oversaw the rent stabilization program in the city of Beverly Hills, and I'm very familiar with the importance of a strong commission in preserving and protecting the rent stabilization program of a city. So with that goal in mind, I very much look forward to working with all of you and meeting you. In terms of the look-ahead calendar, today the appeal that's scheduled is D4527. We'll also be receiving a presentation from Hernan Molina about the Justice for Renters Act and discussing Resolution 24-649 related to the appeal D4864. On June 27th, we'll be hearing appeal D4837. There will be a presentation announcing the annual general adjustment for the allowable rent increase and discussion about adjustments to the relocation fees and temporary relocation expense schedule based on the May to May CPI. On July 11th, appeal D4849 will be heard, and there will be a reorganization of the chair and vice chair, as well as commission liaison appointments to other commissions and advisory boards. And that concludes the look-ahead calendar for today.
Thank you. Do any commissioners have any questions? Ms. Aviles or a new manager, Cameron, do we have a presentation for Is that the item now? Okay.
Now we'd like to welcome Hernan Molina to give his presentation on the Justice for Renters Act.
I know because we have the West Side City's Council of Governments today, so Commissioner Kerpis and I were maybe like 5 hours ago here. Anyway, good evening, members of the public, commissioners, fellow colleagues. My name is Hernan Molina. I'm the Governmental Affairs Liaison for the City of West Hollywood. I've been part of the city for a long time, like Agassi, Commissioner Topchen, I would say. We were in our 30s. That was a while ago. Early 30s, I may note. It's a pleasure to be here with you. I haven't been at this commission since most of you have been appointed, except for Commissioner Kerpis and Commissioner Topchen. You and I have had a conversation with Commissioner Bass about making a presentation. And believe it or not, although the City Council adopted a resolution in support of the Justice for Renters Act, technically the ballot initiative, the proposed ballot initiative, has not been deemed qualified yet by the Secretary of State. But that's not here or there because it's a technicality. It's going to qualify. They have the signatures. The signatures are sufficient. And I was actually reading and had worked on a presentation, but we couldn't put it there for you to see. This is a very simple, I would say extremely simple proposal. And while it's not published yet by the Secretary of State, I can see the question being whether or not the voters in California think that municipalities, counties, local governments should be able to regulate rents at the local level. Because basically what this Justice for Renters Act does is repeals Costa-Hawkins Rental Act, which I'm sure you are familiar since you are adjudicating cases. In most cases are rent control apartments. But if this were to pass, our rent stabilization ordinance could be further expanded. Because one of the things that happened, and legal counsel could correct me at any time, so please do so if I say something inadequate. I am not a lawyer. One of the things that we were no longer able to do when Costa-Hawkins passed is to regulate the price of rents when there is a vacancy in the buildings. Landlords today are able to set the initial rent for a rent-controlled building, and then rent gets control, and the commission sets the rental increase. Most municipalities in California, there is no rent control. What this will do is allow those municipalities to enact a rent control ordinance with whatever local flavor they want to do so. One of the things that Costa-Hawkins also does is prohibits the regulation of rents in single-family homes and condominiums. So that could also be fair game. Now, you can imagine that single-family owners, homeowners, and individuals who have one condominium and rent that condominium may have an issue with that. Now, in today's rental market, upon the approval, I believe it was in 2017 or 18 of AB 1482 by Assembly Member Chu, there is a cap on the amount of the rental increases, even if your jurisdiction is not subject to rent control. And I believe it's 5% plus the cost of living increase. And there are some caveats to the to which unit qualifies. If a person has a condominium, and that is the only property, or it's a single-family home, and it's not a corporation, then those units are, for the most part, exempt. Now, AHF is leading the effort. There are some other groups, like the Coalition for Economic Survival and other renters groups in the state that are pushing for this. And it's not surprising. You know what's happening in California and in the rest of the nation, but largely in California with the increases in rents. Now, one of the things that were in my presentation, which I will email it to you, there are some bills in the state legislature that are dealing with security deposits, that are dealing with the number of single-family homes or units that a corporation can have, because through purchasing volumes of units, they are creating a monopoly on the market. And that bill, which unfortunately I don't have the number in front of me, is being spearheaded by Assemblymember Alex Lee from San Jose, a jurisdiction that, albeit came later into the game of rent control, did enact quite a substantial rent control ordinance. This is if I'm well educated, which I think I am, this is the third time that AHF is trying to pass this initiative. And if this is a repeat of what happened, you're going to see large corporations, big apartment owners groups bundled together to defeat these. And I have to tell you that in conversations with people both in the Republican conference, if you will, or caucus, but also in the Democratic caucus, there is quite a bit of fear of how these could impact the rental market. So, to a point that some Democrats are concerned that this remedy could be could impact the rental market in a negative manner by people deciding not to rent once their jurisdiction becomes control. That's just information that I'm sharing with you. This is not here or there in the sense that the City Council did already support, as we did in the two past ballot initiatives. I want to pause now and ask you, commissioners, if you have any questions for me. And Commissioner Topchian, I imagine you do.
Yes, hi, Hernan. Mr. Molina, it's good to see you. Back to the commission. You mentioned the Assembly Bill 1482, the Tenant Protection Act, that sets the limits on the rent increases for non-rent control units in California. So if this is passed, how this will impact that AB 1482, if there would be any effect on that?
That's a good question. AB 1482 is law in the entire state, and I can tell you that in conversation that I had with Gloria, and I'm going to disclose something very personal. I recently became a landlord of a condominium, and I had to do the due diligence to figure out, when I rented it to a friend of mine actually, what I had to check to disclose and make sure that he got all the, and he's a real estate agent, he's my real estate agent. he made me a landlord in a way. And even though, it was Hollywood and my unit is exempt because it's a condominium, this would not apply under 1482 for the extent of this is a condominium. But for apartment buildings, a local jurisdiction would be able to set the rent increase. But if Costa-Hawkins is voided, as this is repealed, they could also regulate the initial market rent. We don't know until the ordinances at the local level are enacted. Now, council is here, and I would just posit this for a moment. If you are a rent control jurisdiction like San Francisco, very on the left, I would want to believe that San Francisco would go for everything that was prior to Costa-Hawkins. I cannot speak for the council here in West Hollywood, and I don't know what Los Angeles could do, because Los Angeles, even though the city council has very progressive council members, also has council members that are moderate and understand the need to protect also small landlords. So I imagine that any rent control ordinance would have some caveats, some exemptions. But again, I think it's new territory in the absence of, well, it's new territory today, since Costa-Hawkins has been in effect for what now, 30 years, 1995.
1995.
February 1st, 1995, correct? It went into effect. So that is a good question. And I imagine the legislature will come up with some sort of regulations, even though this is approved by the voters. The ballot initiative could be modified with 2/3 of both chambers of the legislature. Now, whether they choose to do something like that or not remains to be seen.
We shall see. Thank you.
Of course.
Thank you very much.
To your knowledge, has any city in California, when they did have, this is prior to Costa-Hawkins, to your knowledge, did any city in California have strict rent control on all of their units, on all rental units, no matter what their age was? It's my understanding that like San Francisco and LA and Santa Monica and West Hollywood had their ordinances back to things built prior to 78, 79.
And
But
1980 as well.
I don't know of any cities that had, those were the main cities back then. So I don't know of any cities that had rent control. And I'm referring to people who fear that there will be a blanket, every unit from day one will be rent controlled. But if we look at our past history, like that didn't happen when we did have total control. Unless I'm wrong, do you know of any cities that did have?
I don't want to speak to that because I'm not educated to. I don't know what happened in the 70s, which I think that's what you're referring to.
Well, even prior to Costa-Hawkins, when it went
80s.
when it went into effect in '95, there were no cities that had rent control.
A total rent control.
Yeah.
That's what you're talking, without any exemptions.
Yeah, we've always
like
understood.
Single-family homes or condos.
Yeah, I guess we've always understood that, yeah, when a brand new building opens up and goes on the market, you kind of have to let the market do its thing because they have to recoup their costs. But then after a certain period, like we chose, our ordinance went into play in '84. Well, it had been '84. So '84 back to '79, that was at least 6 years or 5 years. Which is kind of a short window, but I just don't think there's any evidence to show that there would be cities that would automatically knee-jerk reaction shut down all the rental market. But I know one of the fears that unfortunately President Pro Tem of the Senate, Tony Atkins, a huge advocate for housing, has with this initiative specifically is the fact that in addition to appealing, I wouldn't say in addition, it repeals Costa-Hawkins, and I don't know if it was intentional they put this in there, but the very last line of the initiative says, and the state will not interfere, cannot interfere with the city's ability to set rents. And the fear is, after speaking to Republicans and developers, is that they are planning to use that statement to override city's ability to do inclusionary housing, to set the rates for inclusionary housing. People can weigh that argument. She's chosen her side on this issue. I think it's a little far-fetched, and they're just buying into. I think it's going to hurt that side more because it's going to get those people to vote for the initiative. And I think that out of all the years that this has been on the ballot, this is probably the best year so far for it to pass, although I do think it's going to be an uphill battle. And then we'll see. I mean, I just can't imagine that cities would get rid of their affordable housing programs.
No, and it would be very counterproductive to what we are trying to address, correct?
Yeah.
I think, if anything, and Governor Brown was not a fan of inclusionary zoning ordinance, but inclusionary zoning ordinance should be mandated on cities because all cities have to meet what is called the RHNA numbers, the Regional Housing Needs Assessment figures. Was Hollywood has 4,000 units that we have to build in 6 years or 7. And we do it because we have a local ordinance that is a 20% set aside if you build a building that is 20 units or more, correct? So imagine if that were to happen in all cities, particularly like Los Angeles, that they have to build thousands, much more than us. Anyway, I digress. Commissioner Bass, you don't have a question for me? Sorry to put you on the spot.
Not about the Justice for Renters Act.
Okay, but you can ask.
Well, you and I spoke on the phone about a different bill. And although West Hollywood is very friendly, I was looking, I forgot the number. I was just looking it up here. 2216.
Yes.
Which would mandate that all renters would have the right to common household pets.
Yes, Assemblymember Matt Haney, and that was one of the bills that I had in the presentation. So basically what he would do is he would prohibit a landlord from asking a tenant, a prospective tenant, whether they are planning to have a pet. However, as the bill was amended, and I think this is probably a compromise, and I'm just saying, based on my experience, I haven't talked to their office or any of the opposition, but it will require the tenant within 72 hours of entering the contract, once the contract is signed, to notify the landlord that they are indeed planning to have a pet. So the contract is signed, and the landlord could not refuse to have the animal. In West Hollywood, as you are well aware, I imagine you are, animal companions that are for emotional support are allowed, and the landlord cannot refuse to do so. And when we have situations that reach the council level, I am aware that individuals were able to discuss these with their physicians and get a note, and that suffices. But Gloria, who has more experience, as she works in the Rent Stabilization Division, can provide you with additional information. But yeah, that's the bill, and that bill is scheduled in Senate Judiciary for a hearing, either on the 18th, 17th, 18th, or 24th. Don't recall the top of my head, but it's one of the bills that is scheduled for a hearing.
And the city of West Hollywood supports that.
We haven't issued
Which I hope we do.
Yeah, we haven't issued a letter of support yet, but we will testify in support of the bill.
Thank you.
And let me explain to you, since I'm here, When people talk about the legislative affairs in the city of West Hollywood, and Commissioner Moore knows this because I presented extensively to the Women's Advisory Board, you are talking to legislative affairs. And while we follow about 300 bills, we don't get involved in every bill, because once you jump in a bill and you put a letter of support, you have to follow that bill. And I give you an example. Last year, Commissioner Kirby's former employer, Senator Skinner, Josh was working for her when she was in the Assembly, had a bill, Senate Bill 233. And that bill was on a particular issue, was on bidirectional electric vehicle charging batteries. When the issue with Texas and abortion became a big issue and her bill was not moving, she got and amended the bill and basically gave it to the pro tem and the speaker to use it as a vehicle to legislate out-of-state doctors being able to perform abortions in California without having the bar certification. Now that bill became law, and then Senator Skinner still wanted to work on the bidirectional, so she grabbed another of her bills, Senate Bill 59, and got and amended it. And this is why I say jumping into a bill is not just a casual thing we do. We have to pay attention, because sometimes a bill changes so drastically, and if we are still on record of supporting, we may be supporting something that goes against our values or has nothing to do with the city. So that's why we try to limit on so many bills we engage with, but doesn't mean that we cannot go to a committee and do a Me Too, rise in support of the bill, so the senators or assembly members who are voting on a bill knows that the city is there to support. And with that, are there any other questions?
I have one quick question. I did not get the number of the bill, so I apologize. But the monopoly on single-family homes that you were talking about, is that one specific bill? And do you know? It is.
Assemblymember Lee is carrying that bill.
Okay. And
Is limiting the number of units they can own. So they don't, basically, few corporations end up owning the majority of the single family homes in the state.
Right. Do you know what the limit he's proposing?
1,000.
1,000. Okay. In the state of California?
I'm sorry?
In the state of California?
Yes.
Okay.
That's a good question. I would believe so, because...
Yeah. Okay. Thank you.
Of course. And I'm happy to forward you I'll send it to Gloria, and Gloria can share it with all of you. And I'm sorry, I haven't had a chance to meet you.
It was nice listening to you tonight.
Great. Thank you. Good?
Thank you, Hernan.
Thank you.
Nice
Thank you for your
to
time.
see you again. Thank you.
Thank you very much.
Sorry, Chair, just before we move on to the next item, just public comment.
We have someone for public comment? Do we know if the mic is working on the podium? What? Oh.
Testing.
Thank you. Please state your name and city of residence, and you'll have 3 minutes to speak. Thank you for being here.
Good evening, Rent Stabilization Commissioners. My name is Victor Omolchenko, and thank you for letting me bring my bike into the chambers. I was just at a meeting of the LGBTQ Commission, which happens concurrently with your very important meeting, and that was an important meeting, and it's still going on. But I just wanted to share in a general public comment how I'm still learning about the housing opportunities that are available in the city, outside our city. And I was able to attend a very good seminar a week or so ago at Plummer Park that was given by the LGBTQ Center. And it was all about the fact that they were accepting lottery applications for senior citizens, LGBTQ plus senior citizens, because there are openings now available in that housing that is east of our city, at the LGBT Center housing, the senior center, I think it's called the Getty Housing. And as you may remember, the city funded 13 beds in that facility that are designated for West Hollywood LGBTQ plus seniors. So plus those 13 units, 25 units for folks who are taken off the streets and need permanent supportive housing, as well as 60 units for the general population. I was at the older adult health fair, and I believe housing is an important kind of health issue, and I did not find this there. I don't know whether you announced in your meeting that this kind of lottery was happening. I guess the folks who have registered with, let's say, the LGBTQ Center may have gotten information about it. But these, lotteries come up, they're here and gone in a New York minute. And so it makes me wonder how people find out about it, because you often hear complaints about, how did that one get into the housing and I couldn't get in? What's the application process? So I feel that there could be better public outreach, citywide, whatever, countywide, about these kinds of housing opportunities. And our inclusionary housing list, the one here in the city of West Hollywood, has been closed since 2019. Maybe it's time to open it up, since we're hearing all about the housing crisis, the housing element. I was with Mr. Kerpes at an earlier meeting. Mr. Molina was there. All of these different legislative packages coming up in Sacramento regarding housing, and it's something that I know we all need to stay on. And so what I've been doing the last week and during Pride is telling my older senior citizen LGBTQ plus people about these opportunities. I think we could do better in publicizing it. So thanks for maybe the extra time, but I do feel this resonates and is an important issue, since 80% of us are renters and many of us are aging.
Thank you, Victor. I see our chair has arrived. We'll give them just a moment to get up.
Good evening. Thank you so much for heading the meeting for me, Vice Chair. I was listening en route, and so the presentation was really good. And so it looks like we are now at the point of our meeting where we are listening to our appeal for the evening. And just checking in with Madam Secretary, do you need to redo roll call, or are we fine to proceed?
We can proceed.
Okay,
And
perfect.
both parties are here, by the way.
The parties in person? Okay, wonderful, thank you. All righty. Today we are hearing Appeal D4527 CD3. It's a compliance determination. The Secretary has confirmed that parties are in chamber. So the instructions that will follow are the instructions for the parties, so you know how the process will proceed. We'll first have our counsel, our legal counsel will give a staff report. Then the appellant, in this case, will be the tenant. You'll come up and speak first. You'll have 5 minutes to speak. You will let me know how you want to divide that time. You can do 2.5, 2.5. You can do 3-2. You don't have to split it at all. Just let me know how you want to do it. The respondent, in this case, is the landlord. You will speak second. You will have 5 minutes. You don't get to split your time. You'll just present your case, and you can respond to what the tenant has said. You can, talk about what happened at the appeal. We do ask that all of the parties only stick to what's on appeal tonight. Anything else additional outside of that, we can't consider it, and so we want you to use your time wisely and stay on topic. When you come up to the mic, just state your name and city of residence, and then you can proceed. Right now, I'll turn it over to our staff attorney, Mr. Jonathan Natalizio.
Thank you, Chair, Vice Chair, Commission. My name is John Adalizio. I am the legal counsel to the Rent Stabilization Commission for the City of West Hollywood. This appeal hearing results from a hearing examiner's decision granting a compliance determination which restored $11 of rent relating to a common area issue of cleanliness of the building. In the original decision, which was issued, the following order was given to restore the rent, and here's the quote. It's to ensure that the building is regularly maintained in a clean condition and to the degree that soot is not present in the common area. The landlord filed for a request for compliance determination, which sought an order that all of the issues relating to cleanliness of the building and property have been resolved, which warranted a restoration of the $11 in rent. With the request, the landlord submitted pictures, invoices, and other documentation. The city issued a notice of work performed by the landlord and invited objections to the rent restoration. Only the tenant which appealed tonight objected to the request, which was timely. The objection challenged that the landlord had not addressed the issues relating to cleanliness of the property. The hearing examiner ordered an inspection of the property, and an inspection report and photographs were produced. After consideration of the request, the objection, and the inspection report, the hearing examiner issued a compliance determination, which in relevant part found that the landlord had substantially complied with the order and granted the request, which did restore the $11 in rent, and no hearing was held. Tenant filed an appeal, which claims that the compliance determination is clearly in error and not reasonably supported by the findings made or evidence in the hearing record. And specifically, tenant is arguing that the property has not been properly cleaned and maintained. The appeal does include photographs, which were not included with the objection or provided to the hearing examiner, and so are therefore new evidence. Staff finds that the decision is not clearly in error, and there is substantial evidence in the record which reasonably supports the hearing examiner's compliance determination. Staff finds that a reasonable person could come to the same conclusion. There's nothing in the record to disturb the compliance determination. Therefore, staff recommends adopting Resolution RSC 24-650. You, as the Commission, have the power to affirm, reverse, modify, or remand the appeal decision of the hearing examiner. The Commission reviews the hearing examiner's decision under the substantial evidence standard, which requires the Commission to make sure there's substantial evidence that reasonably supports the hearing examiner's decision, is credible and of solid value. If that evidence is found, then the decision must be upheld, even if there's also evidence that could support a different outcome. The Commission does not substitute its judgment for that of the hearing examiner or reweigh the evidence, and as it relates to questions of law, the Commission applies an independent standard of review. Thank you.
Thank you, Mr. Natalizio. Are there any questions from the commissioners? Yep, Commissioner Kirby's.
I just want to confirm that in our packets that the pictures on page 40, actually technically 44 through 40 through 51, those are the pictures submitted by the inspector, right?
Correct.
The person who went out and inspected. Thank you.
Vice Chair Moore.
And to confirm other photos, pages 30 through 39, would those be considered new evidence and we cannot consider them?
Yes, those were attached with the appeal, so if the Commission did want to consider them, they would have to find that it meets the exception.
Okay, thank you.
All right, seeing no additional questions, we will have the tenant, who is the appellant in this case, to come forward. Oh. All right, we're going to bring the microphone over to you. All right, and just state your name and city of residence and let me know how you want to divide your time, and then you can begin.
My name is Lynn LeMay. I reside at 1279 North Harbor Avenue, Unit 3, West Hollywood, 90046. I've resided there for 33 years.
And how do you want to divide your time?
Well, first of all, I'd like to address one issue that the attorney stated.
Before
He
you
made-
before you
he made-
begin, we just have to know how you want to divide your time, and then you can.
Two and a half, and two and a half.
Okay, perfect. Go ahead.
Thank you. He made a comment that said that there were photographs that were not submitted by the tenant to the Rent and Stabilization Office, which is not true at all. I supplied the photographs. They were in an envelope. I took them down there myself, and I specifically wrote on the outside that they were to be given to Eric, the gentleman that I've been told many times is the one in charge of scheduling these hearings and handling the paperwork that I fill out when I go down to their office. I then was told by Eric that he never received the envelope and he never got the pictures. So therefore, that's not my fault. So I mean, I just want to make that statement because there were lots of pictures in the folder of various areas in the building that were very badly damaged, slash marks, black soot, where a variety. Anyway, I just want to say that that's whatever. Anyway, it remains true that those pictures are still as they were, and the damage is still there. Many of them have not been cleaned or removed at all. And as a result, because I myself have built buildings before, I've worked in the design business for many years, I've overseen the construction of many houses and business offices, etc. I know that certain marks cannot be removed just by soap and water or by strong cleansing, They have to be sanded off and probably repainted, and that would solve the problem. I've been told recently that Scott Properties is looking into the fact of repainting some of the areas where these damages currently exist. And I would request that if that's true, then why don't we just continue with the $11 a month off our rent until such time as Scott Properties does repaint those areas, in which case it would clean up all the pictures that you've seen where all the damages exist, and then it would be a moot point and we wouldn't be here.
Are you done?
Pardon me?
Are you done with your 2.5 minutes?
Yes.
Okay. Just to address some of the points, just for clarity. So in the lower decision, originally where the rent reduction was granted, the $11, the hearing officer did that based on like the cleanliness standard of it not being cleaned. And when the investigator went out to the apartment, he looked at he saw the marks and said that it wasn't from sort of being dirty, it just needed to be painted. And since those two things are different housing services, we can't consider whether it needs to be painted or not. We can only consider the cleanliness of it. And then while we have you, do any commissioners have any questions for the tenant before the landlord comes up? Okay. All right, thank you. So we'll turn it over to the landlord, and then you will have your time to rebut. And we're working with one microphone this evening, so we'll have to share. Thank you.
Hello, my name is Daniel Monji, and I'm with Scott Properties, and I'm here on behalf of the landlord. Do you want me to start with the, yep, okay. So basically our position is that the cleanliness isn't the problem. An example of what she's seeing is somebody that has a bicycle will go up the stairwell. The tires will then hit the wall that is white, and it'll make like a little mark. And these things happen, and I see them happen, and I supervise, over 30 buildings, and so these things happen, and I had actually a meeting with Ms. LeMay yesterday, actually, to where we walked the property, and I wanted to show her. Hello. These things are not dirt. It's like a paint cosmetic to where yes, the building could be beautified by painting, and that is what I'm actually working to do with the owner, but it has nothing to do with the cleaning. And you can't mistake in those two things in this situation. And I think that's why the inspector came out and found that the building was clean, because it is. And that's pretty much what I have to say on that.
Okay, looks like we have questions from some commissioners. We'll start with Commissioner Topchin.
Thank you, Chair. Good evening, sir. I'm reading the specifics of the order from the examiner that says specifically ensure that the building is regularly maintained in a clean condition and to the degree that soot is not present in the common area. Can you explain what was specifically done to comply with this order?
Yes, we have employed a janitorial company in which I have the copy of the payments that we've issued to them, and they are assigned to the property weekly.
Are there additional questions?
Since right after the order was issued, you hired the janitorial company?
No, they were actually hired before that, but there was an issue with, I guess, it being only deep cleaning supposedly once a month. So what changed it was we decided that we would make it weekly.
So I guess, yeah, well, my question, maybe I will have to repeat it again, because there is a specific order from the examiner, right? Yes. You went to the hearing, and the hearing, the examiner specifically orders this.
Oh, from
So
the
what,
original,
right,
the original, oh
right.
yeah.
So what was done at that time, right after the original hearing?
The original, yeah, it was basically enacted a janitorial company to then replace the actual cleaner that was hired before that was only once a month. It was a janitorial company, and they did an initial, what they call deep clean, initial cleaning, and that basically knocks out any deep cleaning that needs it, and then the rest is just maintenance, just maintaining that.
So that was different from what was done before, just a regular maintenance cleaning?
Yes, correct.
So you would say that the deep cleaning was something that was new, implemented?
It was in response to
this order?
Yeah, because we thought, well, obviously if the hearing, the inspector finds that, you know, it warranted, that brought all eyes on it.
And the stains were removed, the soot was removed completely?
Oh, yes.
Okay. All right. Thank you.
All right, thank you. Seeing no additional questions. Oh, Commissioner Rory.
Thanks for being here tonight. Do you know when the building was last painted?
The building, at least for the last 30 years, has not been painted, as far as the exterior of the property.
That's what I meant, the exterior.
Yeah.
So it's due for a paint job?
It is due for a paint job, and I am the #1
proponent
for that, absolutely. And I'm working on actually doing that. What I did, you know, as I had a meeting with Ms. LeMay, I let her know that while there is no dirt, and those are like, let's say, tire marks from the bike, I still believe that I want to have the entire stairwell painted just with fresh coat of paint on the interior of the stairwells. But the exterior of the building, we got an estimate at $60,000. The owner right now can't really, you know, do that. I'm trying to find alternatives for the exterior, but there's no crack or there's no actual damage to the building, let's say. It's just not the, you know, might be not the best looking building on the street.
Okay. Do you have any sense of when you might be able to get the building painted?
On the exterior?
On the exterior.
My hopes is by the end of this year.
Okay.
As far as the stairwells, though, and all that, I'm going to be doing that within a week or so.
Okay. Yep. Thank you.
And to confirm, did you say it was 60 or 16 for the exterior painting?
60. 60.
60. Okay, thank you. Are there any additional questions? All right, thank you so much. If you will pass the microphone back to Ms. LeMay.
Do you mind if I stay seated?
That's fine. Let me just check in with the secretary with how much time you have.
3 minutes remaining.
All right, you have 3 minutes, so you go on.
Thank you. First of all, I I stay home, I'm at home Monday through Friday, almost all day long. I see people that come down the driveway, I hear people around the building working. There is I repeat, no maintenance people that have ever come there on a weekly basis, except 2 Hispanic ladies that showed up one time only. One spoke a little English and her mother spoke none. They had brooms. They did not have mops. They said that all they were supposed to do was sweep. That was it. And I showed them dirt on the steps that were leftover garbage and feces and pee from dogs that are in the building. And they said, we don't mop, we don't clean up those things, we only use brooms. They only came twice and then they disappeared and they never came back. When he said there was a deep cleaning of the building done, I again want to say, I don't believe that ever happened. I don't know what they thought they deep cleaned, because had I heard that happening, I would have been out the door to go look at what they were doing and ask questions. That didn't occur. I cannot believe that somebody could come to that building and do any deep cleaning work, which makes noise, and there are certain tools and equipment that make a sound, that I wouldn't have heard it and seen it. And the other thing is, why, if this examiner came and took photographs, and it's mentioned in all these documents that this examiner came, took pictures, and then submitted the pictures, why is it that the examiner couldn't have let me know they were there, to where I could have gone outside and shown them the areas that I was complaining about, and I could have shown them the pictures that I had in my possession? And they said they walked around, they took photographs, and they submitted them, which nobody that lives in the building ever saw. I never saw the examiner. I don't know why, as tenants, why we couldn't have been told that he, she, it were coming, to where we could have met them and we could have pointed out the areas that I'm complaining about. And then she would have something to compare apples to apples. And I think that would have been the correct, proper thing to do. And I mean, I don't see how she could have been around the building for more than, if she was very quiet and she just walked around the building and just looked and then she left, that's probably how she came and went and I didn't see her. But why couldn't somebody in the building been told she was coming? And then I could have walked around with her and I would have said, look at this wall, look at this floor, look at this, look at these steps. No. So it's like, anyway, that's the end of my time, I'm sure. And I'm exhausted. I'm exhausted at the fact that people don't ever do things in some logical, sensible fashion. It's either they say certain things are done and then I can't dispute it, and I still would like to know who hired this inspector and why weren't somebody in the building? They send me. I have gotten, and as I mentioned to this gentleman right over here at the rent and stabilization offices, I've gotten 7 copies of every single thing.
That was your time.
Identical to this meeting tonight. I've gotten 7 ones in the mail, completely separate. Why do I need separate copies of the exact same thing?
I'm just going to ask that you wrap.
I don't know. Never mind.
And is there an extra book at the podium? Is there an additional book at the podium, a printed one? Correct. Oh, the book, like the book that we normally have at the podium, is it there? That one, yeah. Okay, I was going to ask that we give one to Ms. LeMay so she can see the photos and the investigation report that's in there. Thank you. Are there any additional questions for the tenant?
I need to put my glasses on so I can see what I'm.
Can you cut her mic as well? We can hear. Okay, seeing no questions for the tenant, we will go ahead and close the public hearing and can begin deliberations. Yep.
Chair, before we begin the deliberation, I have a couple of questions for staff.
Absolutely.
The tenant specifically mentioned the inspection process. What is the procedure? The inspector, obviously the examiner ordered the inspector's visit to observe the building. Wouldn't that require the contacting the landlord and the tenant so they don't have to be there present, or if rent staff can mention?
Sure. The practice has been that if it's a unit-related issue that they're going to inspect, then they'd absolutely contact the tenant. If it's a common area issue that the hearing examiner has asked, we don't necessarily contact the tenant or the landlord. because what ends up happening in that case, sometimes they take over the inspection and they don't allow us to finish what we're there for. But we do at least, as far as my experience has been, is we will contact whoever is the reporting party on the inspection report, and we'll say, we're going to be there at this time, at this date. I'm going to finish my inspection, and then I'll go to you if you have any questions. But we kind of want to take over on the common areas because there's a tendency that they will want to ask more questions, and we feel that it's better that we do the inspection itself. We will ask in this particular case if that was done or not. The person on the inspection report is not Ms. LeMay, it's another tenant in the building, so it may be that that tenant was contacted or not, I'm not sure, but that could be information that we can get from the inspector.
Okay, but to gain access to the premises, would the department required to notify the landlord of the visit?
Yes, if it's a location that is, for example, a security gate, then yes, we would contact the landlord and say, this is the date and time we're going to be there.
And I'm not sure about this particular building, if it is secured or not.
I don't think so,
I
not
don't
by
think
the
so, right.
Google Earth.
Okay, so basically, we can say that the landlord was not notified about the inspector visit.
I can't say that at this point. It may be that they were.
The reason why I'm asking is maybe irrelevant. It's just, it probably will be irrelevant, so I'll refrain, yeah.
Okay.
The other question I would have, not the question, but the comments I will make during the deliberation, Chair. Thank you.
Thank you, Commissioner. Are there any additional questions for staff? Commissioner Rory?
Can you remind me what the code says about needing to paint the exterior of the building? Is it 15 years?
7.
It's 7 for, and that's the interior, isn't that the interior rule as well?
Talking about exterior is 7 years, interior of a unit's 4.
Oh, interior is 4. Okay, and exterior is 7. And then for this particular building, do we have a record of anyone filing for a reduction in housing service for the exterior paint? Obviously not being done in the last 7 years.
At least relating to this case, like this 4527, no, exterior paint was not a part of it ever. I don't know, and that'd be outside the scope of this hearing, but
I understand.
I would say that if it has not been painted in 30 years, then
Somebody could file a request for a rent reduction for the
Yes,
exterior paint, in theory.
Yes.
Okay.
Just to follow up on Commissioner Rory's question, you mentioned the time frame for exterior paint and interior of unit. What are interior common areas paint?
I think the exterior, let me check. I think there's just exterior of the building, which would be everything that's not in a unit. And then unit.
Having successfully won a case before a hearing examiner on interior common painting, I'm aware that that's separate. But I don't remember what the years are.
I believe it's just 7 for anything that's not interior to the unit. So
Okay.
it's everything else that's actually exterior of an individual unit is 7, and then everything for a actual unit is 4. I don't know if there's anything
Regarding paint specifically.
paint specifically. Yeah.
Thank you.
So unfortunately, the public hearing portion is closed, so we wouldn't be able to take comment on it. But if you stick around for public comment after we're done deliberating, you can make a public comment. All righty. Okay. All right, thank you. Commissioner Rory, would you like to kick us off? Thank you.
Thank you both for coming down tonight. I am inclined to support the staff's recommendation tonight. I think that, as I understood the tenants, that I think all of the issues that all of the painting and cleanliness issues that were referenced seem like they would have been resolved if the exterior of the building gets painted. And we heard testimony from the management company that that's a priority and that they are going to be, they have received an estimate to do that, and they're hoping to accomplish that in in the near future, maybe by the end of the year. And it sounds like the remedy here, just to put pressure on the landlord to get the painting of the exterior done, which sounds like it would resolve most, if not all, of the smudging, would be for someone to file a application for a rent reduction for the exterior paint not being done in the last 7 years. So for all those reasons, I'm inclined to adopt the staff recommendation, but it's not for lack of sympathy to the tenant and understanding that seeing all those smudges on the wall must be very bothersome and wanting to do something about it. I just don't think that this appeal is the right way to go, and I think we have to follow our process, and so I would adopt the resolution.
Thank you. Well said. Commissioner Kerpes?
I too would agree that we should affirm or I would be voting to affirm the hearing examiner's determination for the same reasons stated, that this is an issue of cleanliness. It was resolved. The evidence that we have in front of us, the 15 pictures or so taken by the inspector, I would always encourage the inspector to try to do inspections without the presence of the tenant or the landlord, so that they are a set of independent eyes. They're the eyes of the hearing examiner, and this is the response that they got back, that it was a clean and maintained property. I would highly recommend that the landlord, or that the tenant, either Ms. LeMay or another tenant in the building, immediately put in writing a request to have the building repainted where you'd like it repainted at. If you felt that you've done that in the past, then count 30 days from that point. And then after 30 days has occurred, file a rent reduction for a reduction in service. That's what I would recommend to the tenant or some of the tenants in the building. And that's all I have. Thank you.
Thank you so much, Commissioner Kerpes. Commissioner Topchin?
Thank you, Chair. What I'm going to say is I'm going to support the staff's recommendation. And I want to focus on specifically the questions before us, and that is the cleanliness and the maintenance of the common area. So the record shows that record shows, including the inspector's report, that the landlord complied with the original order and established the maintenance, the regular maintenance, and that's the examiner's findings. So I cannot reweigh the evidence, and I cannot change I don't have anything that would allow me to substitute the judgment of the examiner, because I don't have any grounds or any written evidence that would say the examiner reached an incorrect conclusion. So therefore, I'm going to support the staff's recommendation, but what bothers me is that I heard completely two contradictory statements tonight. Is the landlord says that there is a regular maintenance on the premises, and the tenant in her argument says that there is none. So there's a huge contrast there. It's not like there is a maintenance, but not that often. It's just there is no maintenance, while the landlord says there is a regular maintenance. So based on that, I would, I want to ask if the commissioners would agree to waive the 6-month waiting period, so the tenant has a right to refile for the same reason if the tenant has a reason to believe that there is, or any proof to show that the maintenance is not performed on a regular basis, so the tenant can bring up the same issue before the hearing. So I would support the staff's recommendation with the request to waive the 6-month waiting period to file a new complaint. I don't know if the commissioners would agree.
Thank you, Commissioner Topchin. Commissioner Bass?
Based on Commissioner Topchin's questions, I have a question for staff, and this is a several-year-old complaint. Would there be a need to waive the 6 months, or is that already passed because the complaint was several years ago?
No, the 6 month provision is from filing. So since this is I think the case from 2020, is that what it was? So that 6 months provision, it doesn't need to be included.
Good point. Thank you, Commissioner. Thank you.
I was inclined to support you. That's why I wanted to know the
okay,
answer.
so yeah, I forgot to say that it was from 2022. So yeah, so in that case, I'm just going to say, since I'm not going to, I'm not in a position to make any suggestions or give any advice. It would be within my comments that obviously the tenant would have the right to file a new complaint if the tenant believes the maintenance is not performed and the building is not up to standard. That concludes my comments. Thank you, Chair.
Thank you, Commissioner Bass.
Yeah, thank you. I'm going to support staff's recommendation just off the bat, but I will say a couple of things that are different than what my colleagues have said. One is, first of all, Ms. LeMay, I am a tenant very much like you. I know when the maintenance is there. I know when the yard people are there. They removed a dead tree in my front yard this last week while I was out of town. It was one of the first things I noticed when I came back to town. So I'm very much like you, and I know when people aren't there. And I'm quite persuaded by the tenant's suggestion that they provided photographs that were not provided to the hearing examiner. However, the hearing examiner did, if this was like another compliance decision and the hearing examiner simply looked at the evidence of the landlord versus the tenant and that was the argument, I would ask for a remand. But because there was an inspector that went out who independently of the landlord or the tenant looked at these things, I am persuaded that the hearing examiner did have a factual record before them to make a maintenance determination here about the cleanliness. I was not convinced by what we were hearing about the painting standards, so I just looked at the city's website, not the ordinance, but the interior common area, according to the city's website, has to be painted every 4 years, and the exterior of the building every 7. And I believe the valuation guidelines for those are quite a bit higher than $11 per month. So I would echo the comments of my colleagues that would be an avenue for the tenant and the landlord to explore as a remedy, and perhaps encouraging the landlord to move forward with exterior painting a little bit more expeditiously. So with all that in mind, again, I'm concerned that photos provided with the with the objection might not have been provided to the hearing examiner, and I would like to have staff look into why that might have happened and what the background is on that. I still believe that the hearing examiner had a full enough record to consider the objection and made a reasonable decision. So I will support staff's recommendation.
Thank you so much, Commissioner Bass. Vice Chair Moore.
Thank you. I agree with all of my colleagues. I will also be supporting staff's recommendation. I do want to start by saying that it's rare that we have a tenant and landlord come before us that say that they met yesterday and walked around the building together to try to resolve issues. So it's really nice to hear that you're working together on this. As my colleagues have mentioned, we have to make a decision based on the evidence in front of us and based on the cleanliness of the building. Due to the fact that the examiner did send an inspector out, which doesn't happen in all of these hearings. I haven't heard of many inspectors going out, to be honest. So that, and seeing the inspector's report and photographs, in my opinion, absolutely have to affirm the hearing examiner's decision here. Thank you.
Thank you, Vice Chair Moore. I'll keep it short because I think all the commissioners have said made some very insightful comments. I'm persuaded by the inspection report and the very thorough record that we have before us that the cleanliness has been remedied, even if the painting and sort of the permanent dirt will still need to be addressed in a separate decision or hearing or just whatever is worked out between the landlord and the tenant. But as for what we have before us today, I am inclined to agree with staff's recommendation to uphold the compliance determination. And with that, I will ask my fellow commissioners if there is a motion that anyone would like to make at this time.
I'll make a motion to adopt resolution RSC 24650.
We have a motion. Is there a second?
Second.
We have a motion and a second. Madam Secretary, Mr. Secretary, roll call, please. My apologies.
Commissioner Bass?
Aye.
Commissioner Kirby?
Aye.
Commissioner Rory?
Aye.
Commissioner Topson?
Aye.
Vice Chair Moore?
Aye.
Chair Wright?
Aye. The motion passes. So the parties, if you have any additional questions or want an explanation of sort of what happened or have just, additional comments to make, you can reach out to the Rent Stabilization Division at 323-848-6450. You can make an appointment online at weho.org, and that will wrap up our appeal for this evening. The next item on our agenda is unfinished business. And before I move on, I would like to just check in with fellow commissioners to see if anyone needs a break or if we're sort of ready to power through the rest of the hearing. I'm seeing power through. All right. All right, so item number 10 is unfinished business. We have a resolution from our last meeting, RSC 24649, regarding case D4864. The Rent Stabilization Commission ordered staff to return with an updated resolution, RSC 24-649, to affirm the hearing examiner's decision regarding application D4864. The recommendation from staff is to adopt the resolution. Mr. Natalizio, do you want to speak on this? Thank you.
Sure, thank you, Chair. So as quick background, at the last meeting for the D4864 case, staff had prepared a resolution recommending affirming the hearing examiner's decision. For the commissioners that weren't there, this was the perhaps infamous burgundy carpet case, maybe we'll refer to it as. And ultimately, the commission, after a robust deliberation, determined that they wanted to reverse in part and remand in part due to the complexity of drafting that resolution. Staff asked that it be brought back at this meeting instead of the time it would have taken to do it at last meeting. And so the resolution prepared tonight, staff believes reflects the commission's deliberation and direction, which reversed the hearing examiner's decision relating to the carpet, finding that it was not of comparable quality, and then remanding the case back to the hearing examiner solely for purposes of valuation, with instructions to open up a hearing for both landlord and tenant to submit evidence regarding the valuation, to specifically analyze the factors set forth in the regulations, and then to sufficiently provide analysis to the commission for why that valuation was chose. If there's any questions about the resolution, or if you find that there aren't things reflective of here what was determined, we can make those edits tonight. But staff believes that this reflects what the commission willed.
Any additional questions or comments from commissioners?
Just a comment, maybe. I think, Chair, Commissioners, I think this resolution reflects completely what was discussed and what was recommended, and thank you.
All right, and is there any public comment on this resolution? Seeing none, unless they're invisible, I believe we are ready to close the hearing on this and take a vote. Okay.
I'll move the resolution, RSC 24649.
All right, I'll second. All right, a motion and a second. Mr. Secretary, roll call, please.
Commissioner Bass?
Aye.
Commissioner Kirby?
I will abstain. I was not here, but I did watch it and do agree with it, but to keep the record clean, I will abstain.
Commissioner Rory?
No.
Commissioner Topson?
Aye.
Vice Chair Moore?
I'll abstain.
And Chair Wright?
Aye. The motion passes, noting the no vote by Commissioner Rory. Item number 11 on the agenda, items from staff.
I just want to take the opportunity just to thank the commission and to my fellow colleagues. It's been an amazing 6 months watching you guys deliberate and making these decisions that improve the quality of life for our residents. I'm very honored to have participated in these 6 months. This is not a goodbye because I'll still be here. I'll be presenting some stuff to you, the commissioners, often. But I just want to thank you. We have an awesome group of amazing people that are making a lot of great choices for our community, and I'm very appreciative of that, and I'm very thankful that I'm a participant of this process. So thank you very much. And I'm leaving you in great hands. We've only seen each other for maybe 3 days this week, and I've learned a lot from him. He's learned a lot from me, so I'm sure he's going to take this commission to the next level. So thank you.
Thank you. Do you want to say anything?
Yeah, I spoke briefly at the beginning of the meeting, but I'm just very excited to work with you all. I am very supportive of the work of the commission. I think it's incredibly important in the success of the program, and I look forward to meeting everyone and working with you moving forward. So thanks so much.
All right, thank you. Item number 12 is public comment. Ms. LeMay, did you still want to make a public comment? If so, you have an opportunity to do so at this time. He's going to bring you the microphone so you can hear. And you'll have, just 1 second, so you have 3 minutes for public comment. We won't be able to respond to you, but you can make your comments for the record. Thank you.
My comments simply are, in looking at this book that I was brought, if you look at the pictures that the examiner took that are in this book, many of them are from her standing on the ground and looking up high at a building and saying that she didn't see any damages. Well, she was looking up 2 floors, and that's where the picture was taken, from her standing on the ground. A couple of the pictures she took were pictures from behind people's vehicles in the parking spaces where they had left their personal belongings. That's not what I'm complaining about. That's not the pictures that I submitted. None of her pictures in this book are any of the pictures that I complained about. Not one area, not one. And yet, in the front of this book, there are some of the pictures that I did submit, and I don't know why those weren't referred to or why they weren't included in the same areas when she later took her pictures when she came and examined the building, when some of those pictures are in this book right now, and they're right there. So I don't know why she didn't go look at those areas and then say something about those specific areas which were what I was complaining about. I mean, after 33 years of living in a building, there has been the lovely man that owned the building in the very beginning when I moved in. He took care of the building. There was a maintenance man that lived just blocks away, and whenever anybody complained of anything, he was right there fixing something. The man got elderly. He wanted to sell the building because he was getting old and it was his only thing of value. He sold the building to some people. They hired a management company that were just horrendous people. He sold the building knowing that the building needed a new roof. And so he discounted his asking price for the building by a certain amount, and the people bought the building. Then the management company hired some roofing people that really killed trees and shrubs and everything in the front yard. They left trash in the driveway every day while they were on the roof working. They were the messiest people in the world. Their tar was everywhere. Then we had, never mind. So then, as you so very nicely mentioned, the painting of the exterior was supposed to be done every so many years. So when we all complained about that, then that particular buyer was told that he had to paint the building. Within a week, he put the building up for sale. He did not want to paint the building because it was too much money. He didn't want to spend the money. So he sold the building to the people that now own the building. The people that now own the building live in Houston, Texas. They've never come to Los Angeles. They bought the building because it was an investment. They lose money every friggin' month. They own that building with the 10 people that live there, that have lived there for so long, and our rent, very nicely, is at a very reduced rate, which I totally appreciate because I live on very little money. The point is, if you buy something as a tax write-off, so you just don't give a shit what the rents are, then the point is you don't want to spend the money to paint the building because that's an expense that you don't want to have to go to. So therefore, we can file a little tax.
Thank you.
But it doesn't solve the
Thank you so, thank you so much, Ms. LeMay. We'll have to move on with the meeting. Item number 13 are items from commissioners. And thank you so much for public comment. Oh, is Victor coming up? All right, come on. Oh, you'll need the mic. I don't think that one's working.
Chair, she can speak to...
Gloria's going to come over. All right, thank you. Thank you, Gloria. Victor, you can begin your public comments. Second time this evening. I saw you on YouTube.
Oh, you did? Oh, thank you, Chair. I came in a little late, and what I actually came in for is I had wanted to speak on the Justice for Renters Act, and maybe that was already covered by was that Mr. Molina? Okay, well, let me talk about, thank you for letting me speak again. On this Justice for Renters Act, last night, the West Hollywood Beverly Hills Democratic Club had a chance to hear from who I think will probably become our new congressperson, Laura Friedman. She placed number 1 to replace our very esteemed Adam Schiff. And a couple of us asked her questions. There were questions about reproductive rights. There were questions about transportation, which she's been very involved in. And I asked her the question about affordable housing and this Justice for Renters Act, which I found out about at one of the wonderful booths during our Pride Festival 2 weeks ago. I mean, besides the pride and the partying and the dancing and that, I really enjoy going to those information booths. What Ms. Friedman said was that it's not totally cut and dry, this Justice for Renters Act, that the developers will come out in full force against it because it wants to repeal the Costa-Hawkins Act, but it also gets more broad in terms of looking at rent control at the state level. And the alarming thing to some of us on the Zoom call was that she also mentioned that there were affordable housing groups that were not too happy with this Justice for Renters Act, that she had not had a chance to read the entire bill. Neither have I. I just was kind of briefed on it at the festival and that. But I just hope that going forward, we can, as a community, which is 80% renters, basically, many of whom are rent stabilized, that we can get behind and learn more about this Justice for Renters Act. So I will look at the video to hear what was said earlier, but I think that briefings should be also given about this act to the LGBT Commission, as well as maybe to the Human Services Commission, that we should know about this because before you know it, the election will be here in November, and we will be deluged, I'm afraid, by a lot of flyers from the developer community. But I hope not many from what Ms. Friedman indicated were some kind of, and she didn't name them, affordable housing groups. So I just wanted to share that with you, and I look forward to our working together. And I will show this right now, even though I haven't read the whole thing. I actually got this. They had the shirts there, and I kind of needed a bigger size, so I went back the next day. I was there on Saturday and Sunday. But it looks like a very important act, and it's an initiative, so it needs voter support. Absolutely. So thank you for listening.
Thank you so much, Victor, and thank you for flashing us as well. We enjoyed it. Items from commissioners. I'll go on a volunteer basis.
Just want to thank Supervisor Gloria Aviles for a wonderful job you did for the past 6 months, guiding us, helping us, answering to all our questions. At times we'll put you on spotlight, but you were really fine because of your background, your knowledge, your expertise was much appreciated by us, by me personally. So thank you very much. And I want to welcome our new rent manager, Cameron, but I didn't catch your last name. But
Cameron Kessinger. Thank you.
Cameron Kessinger. So welcome on board. Hope we'll have a good relationship, and we will have a lot of questions for you. Thank you.
I echo Commissioner Topchin. Thank you, Gloria. Welcome. And also welcome, Victor. It's like old home week with 3 of our former public facilities commissioners all in one room. But it's always good to see you.
I just want to thank Gloria. It's been so wonderful having you here for the last 6 months. I actually can't believe it's been 6 months. It went by fast, but we will miss you, but looking forward to seeing you in other capacities at our meetings. And welcome, Manager Kessner. And I also want to thank Roger as well for sitting in for Diane. It's been nice having you here as well. So thank you.
Commissioner Kirpies?
Yeah, just have a couple things. One to comment, one of the public comments tonight, but from Victor, was the housing lottery for the LGBT Center. And one of the things that this commission used to do is have, it was controversial, it was questionable, but the bylaws were changed a couple of years ago, about 7 years ago, I guess. We don't cover housing anymore. We only do rent stabilization. That doesn't prevent us from bringing information like that to the public, but that's the first time I had actually heard of it as well. So thank you for bringing that up. I think it's important that I agree with all the comments that the public, in the public comments about we need to do better at advertising this stuff, whether it's in our jurisdiction or a nearby jurisdiction, whether it's one of our 15 or 13, 12 units that we purchased or not, we should be advertising this stuff. There's a huge need, and I think the city should do a better job at that. Regarding the, I was going to ask, maybe is this something that we could possibly see about the city advertising on social media if they aren't already, since we do have a relationship with the LGBT Center?
One of the things that we're actually going to be looking into, because Victor did mention that 13 of those units were funded by the city, so there may be, if those units are currently vacant, then there may be an opportunity for the applicants on our wait list to be housed in those vacant units that were assigned for the city. But Cameron and I are going to be looking at that, coming back into the office and figuring out if in fact there are 13 units and if those units that are being advertised are part of that stock.
I know some of ours were transitional youth. I don't know if we had one for senior, but yeah, that'd be great. But even if those units, that is our responsibility. But I'm even talking about the other units in the building. If there's a lottery open, that we should advertise for that as long as our residents are eligible, which I believe they would be to enter the lottery. But that was my request. The next thing was just the Justice for Renters Act. There's going to be a lot said about the act. I urge everybody to read it. It is very, very, very simple. All it does is repeal Costa-Hawkins. The line that people are getting upset about is an additional line that basically says the state shall not interfere with the city's ability to set rents, to regulate rents. So that's the last line. That's what everyone is panicked about. I don't buy into that panic. I think that there's desperate acts right now being made, arguments, new fears being brought up because this is the closest we have come in 25 years to get this passed. Sure, next year might be a little bit better, depends on what the housing market is, but right now the housing market and the rents are as high as they've ever been, so now is the closest time that this bill is going to, not this bill, this initiative could pass. So I think people are freaking out and trying to scare people when all it does currently, and I think back to when I worked for Assemblymember Bloom during the COVID pandemic. We received hundreds, if not thousands, of calls of people demanding that their rent be erased, their rents be stopped. The state has control over that right now. The state should not be controlling keeping the cities from being able to help their residents. And so the worst case scenario is that our cities make bad decisions. And if our cities make bad decisions, we as residents can go to our city council and say, stop making bad decisions. Don't let that happen. Whereas right now, sure, you can go to Sacramento and say, stop making bad decisions, but Costa Hawkins was a bad decision, and it's been there for 26 years. So even if there is a downside to this piece or this initiative, I urge people to lean towards their local city councils where you have more control and more influence over the decisions that are made, so that if you don't like what's happening with the rental market or the housing market, or you don't like that the state is no longer requiring that cities do affordable housing, then you can make your council require it, like City of West Hollywood does, like Santa Monica does, like so many, even the City of Los Angeles, who probably does, they try. Even Beverly Hills now is requiring inclusionary housing. They've never done that in the past, but they are doing it now. So these are things that not the state's requiring, this is what the city's requiring. So that whole argument about the state will no longer be able to influence or regulate rents, fine, that's fine with me, let the cities do it. So I just urge everyone to read it for themselves, but it's very simple. There's not a whole lot of reading, it's all on one page. The next thing I wanted to say, this is probably the most important thing, is thank you, Gloria. I echo everything that's been said. One of the things I think that over the last 6 months that I most appreciate is how responsive you have been to any of our requests and responding in a timely fashion. So I really appreciate that. And I'm glad you're not leaving. I'm glad you're still going to be around here. And then also just FYI, I will not be here on July 11th. My great aunt is turning 100, and so I'm going to be up in Oregon to celebrate that with her.
Anything from you, Commissioner Rory?
Thank you, Gloria. And for the look forward calendar, do we have one more meeting before the chair and vice chair nominations? Is that going to be August? And the only reason I ask is that
I think it's July 11th, so we have one more meeting.
we do. Since I'm the newest member of the commission, maybe before at the next meeting, we could have some discussion about what that chair and vice chair nomination process looks like, and so that I can kind of get a sense of how this works. Some commissions I know tend to promote the vice chair, which is great. I just don't know how this works on this particular commission. So whatever insight we could have to talk a little bit about that, just in preview, okay, I would appreciate. But
I think we're probably one of the more traditional boards that do it in that way as well, sort of the longevity of it. That's how it's been since I've been on the board. So I hope that answers. Oh, and Commissioner Topchin and Kirby's obviously. All right, so maybe we just, I don't know if we need to agendize it, but we can sort of just chat about it in the next meeting once folks have kind of thought about it. I guess for my comments, I may not be at the next hearing, in the next meeting, because I'm also turning 100. So no, it's my birthday, but different age. We'll see. But I didn't expect Gloria to say that this was her last meeting today. I think that was like a punch in my heart. It's been such a pleasure just getting to know you, looking over, and like you just sort of always have this exuberant energy about you, this kindness about you. I mean, your knowledge of what the city, the history of the city and the rent stabilization and all the effort is just unparalleled. So thank you for the many hours you've spent just sort of helping me to understand more of that stuff. I can't believe it was 6 months ago where sort of, I think it was the first meeting where you said this was the first meeting of this commission that had ever been, ran by 3 women of color. And I've just held that with me, just the sort of the power in that. So I do appreciate you. I'm also happy that you are still going to be with the city. We just won't see you twice a month now, at least not here, but maybe, I'll just bother you more in your office now. But thank you for all that you've done for us. I appreciate you really. And item number 4 is the adjournment. The next meeting of the Rent Stabilization Commission will be held on Thursday, June 27th at 7 p.m. in the West Hollywood Park Public Meeting Room. Same place, same time. Thank you for coming out for public comments. Good night. I forgot I didn't.
animals and their guardians.
We're such a pet-friendly city, and it made sense that the